Welcome, everyone, to Relate Humanly. I'm your host, Rob Nuttleman, employment attorney, mediator, and public speaker. Today, we're talking with my paralegal, Sophia Freyer. We're going to be talking about employee handbooks and policy updates for 2026. So, grab your cup of coffee, water, tea, whatever it is you like, and let's get started. Well, welcome, Sophia. It's good to see you. We're working opposite ends of the e-verse today, but that's fine. I'm glad to see you here. How are you doing?
I'm doing well, Rob. How are you?
I am doing extremely well. Thank you very much. So you and I have been working together, doing a lot of handbook updates for 2026, and I know we're kind of mid-year, but it's taken a while to get through all of them. Every year we've got a number of different handbooks to go through for our clients, looking at best practices and what things we need to update. So we were talking that this would be a good thing to kind of share with people.
Yeah.
So I know you've been spearheading a lot of some of the initial things. What are some of the policy updates that you want to talk about today?
Sure. A lot of handbooks, there are specific regulations that apply depending on the amount of employees that you have. However, in terms of 2026 updates, it's not that that's irrelevant, but many of them apply to all employers, even if they have less than 10 employees. So if you think, I'm in the clear, this may not apply to me, it's always a good opportunity to check because it usually does. One of the biggest updates was definitely the changes made to victims leave or victims of or families who are victims or many other things. The point is there's tons of different leaves for, victims
Yeah, and
and
when we talk about victims, we're talking about victims of
victims.
crime, domestic violence.
Yes.
Yeah, what are some of the different things that people can use or have time off under that victims of crimes or family members of victims of crimes?
Well, you can use it's typically unpaid time off, but you can use time off, if you are a victim of violent crime, if you have to go to a trial or any type of civil proceeding for a violent crime, if you support a family member, as part of and who was affected by a violent crime, you get time off for your employer through that. And basically, there were 3 separate policies for that, and now, there you can certainly roll them all into one, but they've just changed them so that there is more expanded types of leave for if you are a family member who's a victim of violent crime.
Yeah, so the labor code for quite a while has already provided, and I believe even possibly parts of the Fair Employment and Housing Act have provided for time off of work if you are a victim of a crime. I believe it started off as just victims of domestic violence, but it got expanded
Yeah.
to other types of violent crimes. It's not
Yes.
all crimes, they're
Violent.
crimes of violence predominantly.
Mhm.
And you get time off for yourself if you're a victim. There also, if you have a family member, certain specified family members, you can take the time off for that. And again, it's protected leave. The employers have to provide the time off. There are some minimum employee standards for each of the different ones. And I always have to look it up. One of them, I believe, applies if you have 5 or more. I think that's the one that's been incorporated into the
Yes.
Fair Employment Housing. And there's another one if you think you have 20 or more. I will be honest with you. The recommendation, what we've been doing for our clients is whether you have 5 employees, or quite frankly, even 1 employee, I just think it's a good policy to have because
Yeah.
if you have
Why
an
not have them have time off for this? Yeah.
yeah, if you have an employee who's been the victim of a crime of violence or suffering from domestic violence, and they need time off, whether it's for therapy, to go to court, to be a witness, to talk to the lawyers, give them the time off. It's unpaid time off. They can use their PTO or their paid sick leave even now if they want to. But so for me, it's kind of a no brainer. I do let my clients know that although this may not apply to an employer of your size, I still
Mhm.
recommend having it because I think it's a good idea.
Mhm. For sure. Yeah.
Now, full disclosure, I am on the board of a local domestic violence facility that helps victims of domestic violence and provides them housing and stuff. So, and I have quite a soft spot in my heart for helping out victims in that sense. So, that might be swaying my decision to have employers and more employers have that in their policies either way. But absolutely, that's one of the updates that I know we've been doing pretty
A
frequently
lot.
this year. What
Yeah,
other
and
one?
That update is a good example of one that's really comprehensive. But there are lots of other updates that are not so that are much more specific in terms of just changing certain verbiage and terminology. Two examples of that, though they go together, they are still separate policies, are pregnancy disability leave and the lactation accommodation. Both of those were updated, but just simple changes in verbiage that weren't very massive updates, but nonetheless, updates. And those two both tend to go hand in hand together. Certainly policies that most employers should have.
Yeah, and also one of the things I think is good to mention is
Mhm.
I am a big proponent of the Cal Chamber Handbook
Yes.
software. I use that for a lot of my clients. The reason I like it is it's fairly inexpensive. I think it's like $350 to get the software license. It's fairly easy to use. Somebody unfamiliar with employment laws or having a small familiarity can actually do it. They go through, they answer a number of questions, and based on that, they will get a handbook that is good enough. It's fairly cookie cutterish, but what I like about Cal Chamber, it's California specific, and it has city and county specific policies. So if you're in the city of Berkeley or Emeryville or Oakland or down in LA County or some of the other areas where there's a higher minimum wage or a different paid sick leave law, that will incorporate.
Yes. And another important thing with paid sick leave, which was also updated in 2026, to keep in mind is that if you are an employer with employees in certain Bay Area cities like San Francisco, Oakland, Emeryville, Berkeley, et cetera, et cetera, et cetera, like Rob said, there are more specific policies that apply to you in terms of paid sick leave, and those get updated. Those are more local policies, so it's a good idea to keep an eye out on those updates. But Cal Chamber does a really good job of putting them all together and making them incorporated.
Now I don't know that Cal Chamber is the perfect solution for every employer. You can customize it however you'd like on your paid sick leave. You might want to have, oh, we're going to go with the state minimum, and but we have a couple of people that work in other locations that have or provide for greater paid sick leave. Well, rather than having a whole separate policy, there are ways you can customize that.
Yeah.
And there is, quite frankly, some language that I don't really like, and so I do like to modify those.
And what language is that, Rob?
Hold on.
Bless you.
Got farting with up. Give
Mhm.
me a second so we can have a pause so I can edit that out.
He has tuberculosis.
Okay, good.
Well, what kind of language is frequent in employee handbooks? I'm thinking of one thing in particular that you very much dislike that is something that you frequently change. It's included in Cal Chamber, but it's also just a common verbiage in handbooks and in general employment policies. That
I think I know what you're talking about.
yeah, no, take
Progressive
it.
discipline.
Yes,
Yeah,
bingo.
I don't. People use that phrase, progressive discipline, and I like implementing progressive discipline. I teach progressive discipline. What I don't like is many of the handbooks l- leaves people to believe that employers have to follow verbal discussion, verbal warning, written warning, performance improvement plan termination, and that's just not the case. And
Yeah,
back in the day, there were a lot of cases where employees would use policies such as that to create this implied contract that you have to do these things. Now, the Cal Chamber software and most handbooks are usually pretty good about saying, hey, these are the different
yeah.
tools, but we don't have to follow any of them. I substitute the word progressive discipline for corrective action. I just think that that's a little bit more palatable.
Mhm.
Um, the discipline can be negative, and I think a corrective action can be positive. And I think if you're handling disciplinary or corrective actions issues correctly, they actually can be positive because you're providing the employee direction on how to improve. It's a whole topic for another conversation about how to do that corrective action, how to have those conversations, and how to, instead of doing a performance improvement plan, we do a success plan. It's changing the framework to be a little bit more positive. So I do like to change that
Yeah.
phraseology, and I always want to make sure it's clear. Verbal warnings, written warnings, discussions, all those things are different tools in our tool
Mhm.
belt, and we will use tool that is most appropriate for the circumstances.
I mean, in terms of other updates for 2026, there aren't that many that are hugely important other than those ones. There were some really important updates in 2025 that kind of still carry over, or just things to keep in mind, like workplace violence prevention plans. And also, there was one small update to the harassment, discrimination, and prevention policy that a lot of employers don't have, having to do with a certain protected characteristic. And it's one sentence, but it's an important thing to keep in mind.
And for
Uh,
those of you, so you know what they are, like race for several years now includes protected hairstyles. And so we recommend where you have the anti-harassment or the anti-discrimination law, where you say we do not discriminate based on race, we put a parenthetical including protected hairstyles.
yeah.
Fairly simple update. Workplace violence prevention plan. That was, 2025, we had a lot of those.
Yeah.
And Sophia, you've been kind of our little firm
Yeah.
resident expert on workplace violence prevention plan. Give us a quick little 3-minute overview on what is it and what is it supposed to be? Why do we have these?
So technically it took effect in 2024, but definitely most employers would, get a more comprehensive ball rolling 2024, 2025. And then there also have been updates. And then another important thing to keep in mind, especially in 2025, because it started then, is the annual training for workplace violence prevention. Because the first training for any workplace violence prevention plan is just going over it with your employees. You don't need to do a formalized training. It's just going through the plan with your employees, answering any questions about the plan. But
Slight correction. Going over the plan with the employees is the formalized
yeah,
training. We don't have to
is
hire, when we say formalized, we don't have to
yes,
hire an outside entity to come in
yes.
and do something over and above going over, hey, these are the terms and this is what our plan is.
Yeah. The formalized training for the first round is just going over it with your employees. After that, it has to be something that's a little bit more formalized. There you'd certainly have a lot of options. We've done trainings for clients before, but there are other HR programs that offer trainings as well. But there are many options, and you can do it depending on your resources and the size of your employer. That being said, workplace violence prevention plan. It is something that can be narrowly tailored specific to each employer. What we typically do is we made our own workplace violence prevention plan based on the Cal OSHA plan, but with a little bit extra, thanks to some extra resources from Cal Chamber that we also make more specific, because the plan mentions specific forms like an inspection reporting form. There are, I believe, 5 different forms, and then just incident reporting, anything of that nature. And those forms are come in addition to the plan, but are not included in the plan. There's also a violent incident log that is included in the plan, and it's expected for employers to keep a log of any violent incidents that occur in the workplace or in and around the workplace, and to keep an eye out for anything that could be potentially hazardous, which is another hazard assessment form, that's also included in terms of it being mentioned in the plan, but it's not something that is included within the plan. It's something that employers have to come up with themselves somehow.
Yeah,
All
we used
yes,
to just refer clients to use, hey, Kalosha has a model
yeah,
template, use that. And we just found for a lot of employers, it's a little confusing how their plan was. And that's
yes,
why we modified our own to make it kind of simpler and do it. And it really should be tailored to your work site as far as what are risks. For an office setting, the workplace violence prevention plan is going to be much different than say for one of my security company
yeah,
one, or for um, a store or something that's open to the public. If I have a gas station, my workplace violence prevention plan may be significantly different. So really is you do want to make those changes. And on the training, the other reason it's coming up this year again is um, for many people, it's year 2. So they should be doing their second year of training. A- Again, how is that differ? Do we want to use an outside HR source? A Cal Chamber, I believe, offers a version.
mhm,
Um, Many payroll companies provide it. If you're part of a PEO, a private employer organization, they oftentimes will provide that training. But you can also do it in house. We still don't have clear guidelines on what that training is supposed to be. The idea really though is to involve the employee so they're aware
yes.
of if an emergency happens, this is what we need to do.
Mhm. In fact, employee involvement is a super important part of the plan. It's like required not only as part of that first formalized training, but it's also it's something that we recommend within the plan, which also came directly from Cal OSHA in terms of employee discipline for not complying with the plan, which one would hope employees would comply with workplace violence concerns. But in the event something comes up, a recommended form is for them to read the plan in full and write down any recommendations they have for making it safer, which sort of instills one that they've actually read the plan and two that they're engaging with it in some way. But at pretty much all levels, just making sure that the employees feel safe is a huge part of it. And I do want to emphasize, like Rob said, you want it to be useful to you. You don't want it to be something that you just kind of have and it wouldn't really help in the event of an emergency or anything like that. So you do want to make it specific to your place of employment, because if you're, if you're working in security, which we made a workplace violence prevention plan for a security client of ours, it looks very different from the 5-person office setting one that we made for another. So those things are really important to keep in mind.
So what were you mentioned that 2025 there were a few more updates in for 2026. Do you remember any of the specifics ones that like, oh yeah, we should talk about that one?
There was a heat illness update. There was updates to workers' compensation. There were updates. There's confirmation for receipts of certain policies like wage and hour policies and harassment, discrimination, prevention, and retaliation policies that you can add into your handbook as confirmation that
Yeah.
those specific policies are read. So,
So on the heat illness,
yes,
the OSHA came out with specific regulations. It was OSHA regulations. It might be a labor code section on if the temperature exceeds X,
yes,
then you need to provide more rest breaks, and both indoor and outdoor. So even if your employees are only indoor, we still need to have a heat illness prevention policy in place, because you might have, like my office, for whatever reason, is the only office in the entire suite that doesn't get air conditioning. So my temperature in my office right now is 72 degrees, where everybody else's is probably at 70 degrees. By the afternoon, it's going to be 74. Well, until it gets some of the 80s, I don't think there's much of the heat illness has to do, but that needs to be in the policy. That's a carryover. The workers' compensation updates, those are more like slight verbiage changes,
yeah,
not really any substantive changes. It's just as time goes on, we find that, oh, we want to make some little modifications to the language because something wasn't as clear, or this is a better way to write it, which is different from, no, we've got this new law. Like, can't remember if it's 2025 or 2024. The available paid sick leave
mhm.
increased. It
It's
used to
2024.
be, it was 2000.
24.
Thank you. It used to be you got employers in California had to provide at least 3 days of paid sick leave. Now it's 5 days. If you use the accrual method, the employee has to accrue or be able to accrue up to 10 days. This is an area with handbooks where it can get a little tricky if you're in a city that provides greater
Additional.
benefits. Because some of them, like Berkeley, does not allow you to do what's called a lump sum. I can't just say you get 5 days.
Yeah.
I can front load it, but it actually does have to accrue, and I can cap the accrual. And many of the cities don't have limits on the usage. What I mean by that, in California, you can, although an employee can accrue 10 days, you can limit them to using 5 days. Some cities, if it's on the books, they can use it. And if you're doing the 1 for 30 accrual method, which is
Mhm.
the common accrual, in a typical year, they're actually going to get 70 something hours, I think, if they're working full time, or if they're working a lot of overtime.
Yeah.
So making sure that we're getting the policies correctly for the cities is an important part of those updates.
Mhm. For sure.
So what are we recommending typically on how frequently to update handbooks?
Ooh, yearly for sure. Um, and I would speak with an attorney, or if you have Cal Chamber, keep tabs on that. But there are yearly updates
Yeah.
every year. So,
Oh, yeah, just about every year. I've had a couple of years where it's like, you know what, we don't really have to do an update this year. There's nothing significant. And sometimes it's because, oh, this is only important for an employer with 25 or more employees, and you only have 15, or you only have 10. Other times it's just such a minor shift that we can probably put it off till the next year. Some years we get huge updates. So certainly every year you need to ask the question, do I need to update
Yeah.
it? And we'll talk in another episode about to what extent you want to use artificial intelligence to help you make that choice. Um, Hopefully you have an employment attorney that you work with, or an experienced HR person in-house or external that you can reach out to. Cal Chamber, again, is a great resource. Many payroll companies provide services. Many of those, though, won't tell you, hey, you need to do X, Y, and Z.
Yeah.
The nice thing, if you have the Cal Chambers, they will actually tell you, hey, there's been some policy updates. These are the updates you need to do, so that you can look at it and decide, oh, yes, I need to update all of them, some of them, none of them, and make those choices. Again, I know I'm doing a big plug for Cal Chamber. I just find it as a very good resource for people that don't have an HR consultant that is a member of SHRM or has a lot of experience. The Cal Chamber has a lot of great tools and things you can use. Now, there have been a lot of discussions. It's not really didn't fall under policies.
Mm.
There's been a lot of discussion, a lot of cases over the last couple of years about alternative dispute resolution agreements, more specifically arbitration agreements, and whether or not they are enforceable when they're not. That is certainly an agreement I would want you to consider as an employer and an employee. Arbitration can be an effective way to resolve cases, oftentimes less expensively, many times more quickly than actual litigation. There are some limits and there are some concerns from both sides as to whether or not it is appropriate. And there are a lot of court cases deciding whether or not those arbitration agreements are or not enforceable, depending on the specific language. And even, does the arbitrator decide if it's enforceable, or does the court decide if it's enforceable? So that is an area of changing law. Almost every year, we've got to make little small tweaks
Yeah.
to those. Other things that we want to have in place, consider whether or not we need a confidentiality agreement. I have a lot of clients in the care industry, healthcare, home care, et cetera, and we get private, personal medical information that needs to be protected. Or I have companies in the high tech industry or other industries where we have internal, confidential, proprietary, or trade secret information that needs to be protected. If you have information that you don't want disclosed outside of the company, you need to have a confidentiality agreement. And we also have to be cautious because we can't allow that confidentiality agreement to prohibit an employee from talking about protected conduct. Like if an employee wants to report a claim to the SEC or to the IRS or the EEOC or any other of those wonderful alphabet soup governmental agencies, we can't prohibit that. We can't prohibit employees from talking about their wages. So there are limitations. Those are just two agreements that I think every employer should consider whether or not it's appropriate for their workplace. So there will be more updates on handbooks. Usually September, October is where we see a whole flood of new statutes, because I think I can't remember the specific dates. It has to be to the governor's desk by X date, and then the governor has until I think October 15th or something like that to sign. And if he doesn't sign them, then they have to start the whole process again. So you'll see November, December, January, a lot of podcasts, emails, newsletters, updates, not just from us, but many in the legal profession and HR profession about those updates. So definitely start looking in the November, December timeframe of each year. What are the different laws? What updates do I have to do so that we can be safe for the next year? Well, Sophia, thanks again for coming and joining us. We'll be talking again. We got a couple other ones coming up in the near future, which we'll be talking about. So everybody else, thanks for joining in. Don't forget to subscribe, tell a friend, hit like, send comments. We always like to hear from you. Thanks.